All right, we've got about a minute to go until we start. Michelle, can you hear me?
Yes.
Okay, good. Okay. And then I am going to ask, I'm going to repeat myself just a couple times too, but I'm going to ask that everybody, besides Michelle, of course, keeps yourself on mute, um, for the next hour, just so we can kind of move and groove since we want to make sure we maximize our time with our honorable judge here. So we have just a few more people joining. I think I'm just still getting emails. And Michelle, again, thank you so much for doing this. This is wonderful. And it's such a treat too. I feel like I don't get to see you much anymore. So thank you very much again for doing this. We really appreciate it very much.
To be here. Thank you for inviting.
Okay. All right. 1 o'clock. Let's go ahead and get started. I know some people will be straggling, but this is being recorded for those who didn't hear me the first time. Um, yeah, so yeah, we can go ahead and we'll take notes on this as well. Michelle, as long as you're okay with that, um, we're gonna let the old robot do that for us.
Sure.
Um, and then again, this will be recorded and sent out to everybody once we are finished. Okay? All right, so the way that this is going to kind of go, I'm going to go ahead and read a short bio of Michelle, and then we're going to go ahead and start with just the start to finish process of an eviction. And then after that, Michelle, I'll just be asking you the questions that the landlords had sent in to us previously. Okay?
Sounds good.
Okay. And then one more time, I'm just going to repeat myself. I'm going to ask that everybody puts themselves on mute. If you're not able to do that, I'm going to go ahead and do that for you from my end. Okay? Okay, so let's go ahead and begin. Again, thank you, Michelle, so much for being here. A little bit about Magisterial District Judge Michele Santicola. She was a deputy attorney general for nearly 10 years, representing the Commonwealth in civil and criminal cases in 23 counties in Western PA, including in jury trials and grand jury cases. Oops, sorry, hold on. And she then entered private practice and represented individuals and corporations in various types of cases. Michelle was a hearing examiner for the Liquor Control Board for 4 years, presiding over licensing issue cases. And then for the past 5.5 years, she's been a magisterial district judge, presiding over thousands of cases, including criminal, civil, and, how appropriate, landlord tenant cases. And I feel like I have to add because it's appropriate. In my previous lifetime, I was running a food pantry in Coriopolis, and Michelle was, of course, a volunteer with us. So um, she, of course, does good elsewhere as well. So I feel like that's appropriate to state. Okay, so one more time, everybody, go ahead and put yourselves on mute. And Michelle, if you wouldn't mind kicking us off with the process of an eviction.
Sure. Okay. Good afternoon, everyone. I'm going.
Hold on 1 second. So sorry. I don't know who else muted. Sorry. Hold on here. Michelle, where did you go? Okay, I just asked it. There you go. Okay, go ahead. Go ahead,
Yeah,
Michelle.
it said it muted me, so there we go. Okay. So I'm going to go through the process, and as we go along, I tend to give like tips and pointers, like here's what I see, here's some downfalls that some pitfalls landlords fail to do this. So if that kind of information hopefully will be helpful to you all, or if you'd rather me just like stick to the facts, I tend to go off in a little and say, okay, here's a story, this happened here, and here's what I would suggest, kind of like practice tips for you guys. The first thing you do, obviously, you come to the magisterial district office and get a complaint form, and fill this out. I've seen here's some just a little issue that folks have. make sure if there's lines on here for rent. So if someone has back due rent, put that on there. Other fees that you're looking for, put that on there for, damages, attorney's fees, whatever is due and owing at the time that you're filing the complaint. And then there's a line for additional rent remaining due and unpaid on hearing date. So for example, you file this May 20th, your hearing date is scheduled for June 2nd. In between there, that rent is going to be due and owing. Include that on there, and I'll tell you why it's an important thing to do. Also, if you're seeking not only back due rent, but there have been additional breaches of the lease, important to put this on here. And here's why I'll tell you. Okay, so you file the landlord tenant complaint. When we get it in our office, our obligation is to set a hearing no less than 7, no more than 15 days from the date we receive this. So we'll set the hearing date. If the tenant fails to appear, number one, the landlord must appear anyway if you want relief. We cannot give possession or even any money according to the rules. Say for example, Hannah's my tenant, she tells me I'm not coming to the hearing, do whatever you want. The landlord unfortunately still has to show if you want relief. So the landlord shows up, let's go back to my first scenario. May 20th is when you filed it. Hearing is set for June 1st or May 25th, June 1st. So now June's rent is due. I see this all the time. Landlords come in and they say, okay, I asked for $3,500, but June rent posted, I want to add $700, whatever. You cannot amend at the hearing upwards if the tenant fails to appear. If the tenant's here, you can amend and say, now you owe me June, okay, the tenant now has notice. If the tenant doesn't show, you can't add to the balance. Versus if you put it on there saying additional rent due and unpaid at the time of the hearing, you anticipate it's going to be an additional $700. The tenant has notice, you put it in your total amount, then you can get that. So that's a pitfall that a lot of landlords fall into, that don't realize that if the tenant shows up, no problem, but 50-50 they don't show up. So just be sure when you are filling out that complaint form that you make sure to put that in there. And then if there are allegations of the breach beyond just failure to pay rent, include that on there. The reason being, again, if you come in and you come for the hearing and you say, okay, here's the issue, they owe $3,500, but they're also have an unauthorized pet, an unauthorized person not on the lease in the building, there's smoking, there's drug activity, any of that. They don't have notice of that, don't appear at the hearing, that can't be presented. That becomes important because if I always ask landlords, is the tenant within the lease term? So for example, Hannah signs the lease in January, doesn't pay her rent April, May, you file, we have a hearing. I can sign the order, I can find in favor of the landlord if it's only rent due. So there's no other breach of the lease, and it's just a matter of she hasn't paid her rent. So there's a balance, we'll say $2,000 balance. Okay, so I find in favor of the landlord, she has 10 days to either appeal my ruling or pay that balance. So if she pays that balance, we cannot move forward unless there are other issues, So what I'm saying is, if she's smoking and you want her out anyway, or even, there are other issues, you're just done. You're sick of dealing with it. without notice to her of the other breaches, she can keep doing that over and over again. I have landlords come in and they get so frustrated and say, I'm here again, I'm here again. As long as she cures that default within those 10 days, she can keep doing it. Now, I always, not all MDJs do this, but I do. I order court costs in addition, because for that very reason. I mean, the landlord is out money when they have to file this. Not only the filing fee, which is hundreds of dollars usually, but, you know, and you can ask for in here, attorney's fees, ask for that if there's an attorney involved, but you know, it costs you guys money to go to court. And if this tenant is habitually doing this, you know, you're entitled to that money. But keep that in mind, as long as they pay that within that period, unless there's a separate breach, you're out of luck, you're stuck with them. Okay, so set the hearing within 7 to 15 days. The tenant then has to be served at least 5 days prior to the hearing. The service is one by first class mail, so we send it out by first class mail. And then we have a constable go and they make an attempt, they have to make a good faith effort to hand deliver it to either the tenant or an adult present at the house. We all know people try to duck, you know, they don't want that service. So if a good faith effort to actually hand deliver is unsuccessful, then it can be posted on the front door, or you know, the main entrance. You can't post it somewhere secret in the back. It has to be posted at the main entrance. Then the hearing takes place. The hearing is, you know, there are very few hearings for rent that there's a heavy evidentiary issue. Basically, the landlord comes in, the landlord says, here's their ledger, if you have that, depending on, you know, your record keeping. They haven't paid, as you see, these several months. The tenant, I've had some tenants say, yes, I did, I paid in cash, I didn't get a receipt. Okay, no. You know, that here's a canceled check. Okay, now we're talking with the dates and whatever. But generally, if it's just a rent issue, it's really tough for a tenant to overcome the landlord's testimony or evidence that it has not been paid. On the other hand, if it's an issue of a breach of the lease, for example, there's been police activity. I usually encourage landlords, if that's one of their major issues, just grab a copy of the police report if you can, if you have it. Now, also, that said, you're filing in the Magisterial District where the property is. So the MDJ involved knows, because if it's a criminal issue, if charges have been filed, they've been filed here in front of me. So this happens a lot. I'll see people come in, yeah, and the landlord will say, well, Your Honor, you know, this issue, you know. But if you're able to grab a police report, that just strengthens your case. If it's something like smoking on property, if you have other tenants who are willing to come in and say, yes, they smoked in there, or I constantly am smelling smoke, or other tenants to come in, you know, it's loud all hours of the night, any of that is helpful. But usually just the landlord's testimony is enough, unless the tenant is adamant, no, this I don't smoke, or you know. I had a case recently where a landlord was trying to evict someone for smoking, and I said, okay, well, that should be pretty simple. He's explaining us there's, you know, ashtrays in the place, it smells like smoke, blah blah blah. I said, okay. Say to her, are you smoking? But yes, I'm smoking in there. Okay, well, she said it's not in the lease. So I said to him, okay, give me a copy of this lease again. He said, well, it's under enjoyment of the, you're disturbing the enjoyment for other units. And I said, that's not good enough. You have to have something prohibiting smoking in there. So that to me, and not to anybody, is not a breach of the lease. So let me actually go back before I go any further down that line. As a landlord, it's really, really important that you take care to draft or have on your behalf drafted a good lease. Make sure, that was a perfect example. He said, I didn't want smoking in there. Well, you didn't put that in there. That's something that's got to be spelled out. I'm not, finding that your interpretation that disturbs the enjoyment of other residents in other apartments qualifies there. Do I personally think that? Probably. I don't want to be beside someone smoking, but that doesn't count. You have to put that person on notice, because if you're a smoker, you want to be able to smoke in your own apartment. So if you don't want that to happen, put that in there. Anything that you want the tenant to do or not do needs to be in that lease. To include, I would include, add language. This is like kind of a catch-all to protect you. Comply with all local, state, and federal laws. That way, if someone's doing drugs or selling drugs from there, it makes it a whole lot easier just to point to that section and say, that's a breach of the lease. Okay. Also, you can have an oral lease. That can happen. I do not recommend it for your own protection, but you can have an oral lease. A lease is not a piece of paper. A lease is an agreement between two people. And so you can have an agreement with terms and consideration being the rent being paid without having it reduced to writing. As the lawyer in me, the judge in me says, never ever do that. So just, make sure you know that as long as the term is 3 years or less, it can be oral. Once you get into a 3+ year lease, it has to be reduced to writing anyway. Okay, so we're at the hearing. Plaintiff is here. You're the plaintiff. Defendant is here. Now, a lot of times, and especially post-COVID, you probably all, I don't know how many of you have been landlords prior to and then after, with all, that changed the landscape drastically, obviously. There's a lot of rental assistance. It's now waning. But I always give landlords the opportunity, if they want to participate and it looks like the tenant may qualify at this point still for rental assistance, if the landlord wants some extra time and it will behoove them to postpone the hearing, I'm all for that. A lot of times I kind of have to explain that even to landlords and say, look, can't get blood from a stone. You may not get anything this way. If the rental assistance is available and this person qualifies, you may want to go ahead and postpone this hearing and give this person an opportunity to go get the assistance, because then that way you're going to get paid. And the whole purpose of it is housing stabilization. So you have to agree that you're going to allow that person to let them pay that back rent, get caught up. And the person, I always make sure, look, going forward, are you able to pay, or are we just throwing good money at bad? If this person had been out of work, now they have a job, great. Get that back rent cleaned up, but you're able to, going forward, able to pay your rent and stay in the house. Housing stabilization. Okay, so hearing occurs. Judgment will say, I find in favor of the landlord. I have 3 days to do that, to make my ruling. I've never not done it on the spot. I think everybody is owed that courtesy. So let the landlord know, that generally the tenant always panics. How does that mean I have to be out today? No. So the tenant has 10 days to appeal to the Court of Common Pleas. The law says that along with that appeal, they're supposed to put either 3 months rent or the lesser of 3 months rent or the back rent due by either cash or bond with the prothonotary downtown. Now, most counties actually make them do that. It's my understanding Allegheny is not among those. So I'm not sure exactly what happens down there, but that's what they're supposed to do, which usually is, if they had that money, they probably would have paid you and not done it. I get that whole idea. However, it's frustrating for landlords, I know, and I tell tenants this all the time when they come in. A lot of times they're indignant and say, "Oh, they expect me to pay. I just don't have it." And I always say, "Well, the bank expects them to pay their mortgage, and the county expects them to pay their taxes, and the utilities expect them to pay their utilities. So you understand, yeah, they do expect you to pay the rent. But in any event, they're supposed to put down that in escrow that amount, and then if they haven't within those 10 days, if they have not filed an appeal, then you come back to the Magisterial District Judge. We then issue an order for possession. We get it to a constable. They have 48 hours to post that, telling the tenant they have 10 days to leave the property or be forcefully removed from the property. If that appeal is accepted by the Court of Common Pleas, then the eviction process is stopped until the Court of Common Pleas makes a determination. They start from scratch. They don't take my word and say, "Look, I think this landlord should have possession." They start from scratch. So you have to go downtown, present to a Court of Common Pleas judge, and it starts all over again. Once they have ruled, if they rule in your favor, then the stay is lifted and you come back here and get the order for possession. It gets posted, and then the tenant has 10 days to vacate. All right, I think I went on for a really long time about all that, but hopefully that was helpful. And I know there were some questions I kind of started looking over. If you want to go from there.
Yeah, I feel like that was really great, and I feel like you did answer quite a few of them. I'm trying to hopefully I don't repeat myself. I circled some that I feel like were outstanding. Um, so I feel like you did kind of go over what landlords should bring to court, what they do first to come there to fill it out. Anything else that you would suggest in addition to the complaint?
What I see a lot is, okay, for example, if there are issues with, say that it's a house, tenants or even an apartment, they're leaving trash around, or they are damaging the property, anything that you see that they're doing, that there's a reason that you want to evict them, photographs, video, if there are noise complaints from other tenants, I've had people come in and show me on an iPhone, listen to this music was a whatever video of what's going on. Anything that you think would help your case, I'm willing to see. I get a lot of nasty text messages tenants send to landlords, emails they send. I'll look at all of that because to me, nobody wants to be in that kind of relationship. Like if you're asking somebody for rent and they're coming back at you with, terrible language or aggressive behavior, I really, that to me says a lot. You shouldn't have to be subject to that. So anything like that you have, bring that.
Okay, great. Okay, let's switch topics just a little bit. Same, on the same line of things. Emotional support animals. Are landlords required to accept ESAs in PA? That's part number one. If so, what documentation should a prospective tenant provide for this?
That, this one is a pet peeve of mine. I've had people even try here to bring it. Oh, this is my emotional support animal. I got this on the internet. Yeah, no. Not all judges are of the same mind as I am. Some are much laxer. However, Pennsylvania has no law, no rules as far as landlord tenant, anything about that goes. However, you have to abide by the Fair Housing Act, the Federal Fair Housing Act. And that says the person must have a disability and proof of that disability, and it has to, they have to, so the burden is on them at that point. And supported, they have to provide supporting documentation of that disability. So if someone comes in and says, I really need this pet, whatever, well, show me your doctor's, a therapist, a doctor, somebody who has said that you have a disability and that this is an appropriate accommodation. And a lot of times it falls off it. No, I just got this on the internet. No. And then there are still limitations there, because what if my accommodation says that a Shetland pony is the proper, and we laugh at the ridiculousness, but we've all seen the airline stuff. Like, people are trying to bring a peacock onto an airline. As landlords, there is no bottom to what the craziness of people that you will, you think, oh, well, that will never happen. It will. What if my emotional support animal is a pit bull that has, and I'm a dog lover for sure, but an aggressive pit bull? Well, there's also limitations. It can't, one, destroy your property. So you don't have to allow a donkey in your apartment. That's ridiculous. You don't have to allow anything that's going to potentially risk the health or welfare of other tenants. So if it's a dog that has a propensity, and it can't just be, well, that's an aggressive kind of dog. But if there's an issue with this dog, or has been issues with this dog, or you have to be mindful of other tenants and people around, because you don't want to end up, excuse me, getting sued for somebody else, getting hurt by this emotional support animal. It can't be an undue financial burden on you to allow this emotional support animal.
Okay. Okay. I am just a quick note. I am seeing so many questions in the chat. I know that there are so many that we could go on for hours. But I am going to outwardly ignore the ones that are in the chat, just because I want to focus on the ones that we did get previously. Okay, so I just want everyone to know that. Okay, moving on.
I'm gonna throw one thing in here real quick that I should have probably said at the beginning, that is a downfall that many landlords kind of get caught up in: the security deposit. And I don't think that I saw that on the list. Maybe I did, but just be sure. So tenant moves out, you have 30 days to either return that security deposit or provide them with a list of damages and why you're keeping either all or part of it. And if you don't do that, you forfeit it, the security deposit, and they can even come back and get double the security deposit from you, regardless of whether they left the place trashed or not. One caveat: they have to provide you with their new address, so you know where to send this letter to. They can't be like, oh, I'm out of here now. If you don't send it to me, you owe me double the security. No. They have to provide proof that they've provided in writing to you their new address. Now, I did see some questions on the email that Hannah had sent to me about proof of these damages. Again, Probably judge by judge. I am very understanding of landlords, I think, in terms of, you don't have to provide to me unless you're asking for something completely unreasonable. Um, a cleaning fee. I know it costs a lot of money to clean, and people will provide pictures to me of the disgusting nature that the house was left in. I'm okay. It takes hundreds of dollars to get somebody to go in there and clean that up. So that's reasonable to me. Um, Maybe another judge would require you to actually have an estimate, a written estimate of that, or a bill that you paid that cleaning company. But I think that's perfectly reasonable. And if there's repairs that need to be made, um, that's expensive. It's expensive to get somebody to repair a hole in the wall and buy the paint. And yes, I think somebody asked on labor, absolutely, because that's an out-of-pocket expense for you. You don't get to just say, oh, I'll just pay for the drywall and the paint. The drywall and the paint didn't hop up there. Somebody had to put it up there. Now, $500 an hour, not reasonable, but it costs money, and it's a skilled labor to have to be able to do the work. So a tenant who leaves the apartment or house in bad condition, or any kind of issues, sorry, but you got to pay for that, and that's the whole purpose of the security deposit.
Sure. I think too that we got a lot of repeat questions on that. I feel like one thing too, I thought that this was an interesting question. You would think that this would be an obvious answer, but who knows? Are you allowed to mark up costs to a certain amount, or does it need to be at cost for the materials, labor? You went over that just a second ago a little bit, but talking about upping the cost.
Yeah, you can't inflate it. It has to be the cost of it. But like I said, cost can include the labor, the time, you can ask for what it costs you to include time and the materials you bought, and yeah, but marking it up, like say that security deposit is $900, you only spent with materials and cost of labor and whatever, you only spent 700. You can't artificially inflate it. It has to be what you actually spent, or if you did the work yourself. Like I'm not capable of screwing in a light bulb. But if you are a person who rents homes or apartments and you're real handy, your time is worth money too. So that's perfectly reasonable to ask for your time. A painting contractor is going to put into the cost of what they do, their trip to Home Depot to get the supplies, whatever. They're going to build that into the cost. So you can build that into your cost.
Okay. Okay, answered that one. So I feel like this is a good one. What are a judge's biggest pet peeve items, would you say?
Okay, I would say probably being unreasonable. So as much as I have acknowledged on the one side, I get very frustrated with tenants who are unreasonable as far as expecting. I always use the line, you know what? He or she is not your mother or father. They don't owe you a roof over your head. Like, you can't come in here and say, well, I just can't pay my rent. I'm very sympathetic to that. Very sympathetic. It's terrible. But they don't have to provide that for you. They have a family that they have to, you know. On the flip side, if, like, for example, during when we had the ERAP money, if a landlord, if there were no other breaches, it looked like they were going to get the money, they were getting back up on their feet. If a landlord would just be like, well, yeah, I don't want them there anymore. Like, be reasonable, but I can't, I can't really think of a lot of, I, sadly, I have more tenant, pet peeves than landlord pet peeves. Other than, yeah, I do get the frustration when landlords come in and if the tenant doesn't appear and they don't understand. It's not that I don't completely understand that May moved to June and you're owed more money. It's just I'm not allowed to increase the amount because the tenant didn't have notice of that. Now, you can argue, yes, they did, because they knew May became June, but legally, if it's not on this, the amount that they have notice of, and then the breaches that they have notice of are the only things that we're allowed to address. So, yeah, that, and then
Okay,
nine
I
pet.
think being unreasonable. I think that's a great answer. Okay. What, I feel like this is another good one. What should the landlords watch out for to avoid discrimination lawsuits? I feel like you could
Oh,
go on about this, but
yeah.
basically.
Yeah, I mean, just your basic, not, you cannot, refuse to rent based on race, religion, sex, national origin, anything like that. We gotta, if you are offering your place for rent, it has to be to everybody. And then same with, okay, I'm gonna evict somebody because, oh, I found out that they're in a same-sex situation and I don't believe that. If you're going to offer your place for rent, you have to put the laws, the fair housing laws, apply. So you don't get to make those distinctions.
Okay. Um, okay. How does one validate the eviction records when doing background checks? For example, when searching the UJS for very common names such as Joe Smith.
Yeah, that's a tough one because obviously, what I would do is if I find, okay, Joe Smith, um, was evicted, out of court 05225, I would then call that court and, you know, try to get some more information about that person or see their forwarding address. Um, or I would, when in the application process with that person, I would say to them, I found on the UJS, there's a Joe Smith with this eviction. Is this you? And I would maybe even put it in the lease or put something, have it in the application with the stipulation that if you default and we have to go to court and I find out that this was you, I'm gonna ask you you're gonna have to testify under oath and what that is going to be obviously immediately a breach and grounds for eviction. And I guess the application process and a lot of, I know, especially a lot of single family dwellings or smaller landlords don't have as rigorous of an application process or even have an applicant. You just have the lease. But I would ask for something under penalty of perjury, having them swear that Joe Smith wasn't them, or ask on there, have you had previous evictions? And if they have, that's something for consideration. One, do you want to rent to this person? But two, is their rent going to reflect that? Is it, they're a bigger risk, or are they going to have to pay a little more?
Okay. How long after a tenant is late do you recommend filing an eviction? Does your opinion change with a tenant who has a housing voucher where they pay very little and the vast majority of their payment has been made by the housing authority?
That's such a good question.
Yeah.
And a lot of time, actually yesterday, I was very surprised and actually had to ask the landlord flat out, why did you wait so long? The rent was 2,000 a month, and he filed, and it was over $10,000. And I said to him, "Wow, why'd you wait so long?" And he said, "Honestly, I wanted to wait till after school was out because I knew she had kids in the school district." And I said, "Wow, good on you. Like, what a nice person you are." But I have landlords who file within 10 days, like if rent's due June 1st, it's late, June 10th, they will file June 11th. I have landlords who will wait till they're at the jurisdictional limit. It's really a personal choice. But I think knowing your tenant's situation is super helpful. Like, have a conversation with them. Like, is something going on? Is there a job loss? Is there whatever? And then also, especially with with ERAP and with different types of assistance, a lot of them want to see a court docket before they're going to release funds. So it is better. I mean, it maybe sounds cruel to sooner rather than later file, but in my opinion, it's better to file sooner. Now, I don't necessarily mean day 11, but it is better to file earlier because it gets the ball rolling for perhaps rental assistance, and or the longer you wait, then if they are somebody who's just gonna go like this, then you're not, out even more money and you can get a judgment, but it could be worth the paper it's written on. Yeah, great. I have this, you have the eviction, but you have a judgment. Oh, he owes me $11,000. Well, congratulations. You're never going to see that money. And as a landlord, like, you don't want to be left holding that huge bag. And do I think on the vouchers, there again, if they are only responsible for a small portion and they're still not paying that, and they don't, take accountability, I think that filing sooner rather than later is probably a good thing. If nothing else, to get people's attention and understand that you're serious, and to get them to have a conversation, because I see so many times landlords who are being kind and being, understanding, then end up holding a really big bag. So you're not being a bad person, you're just looking out for your interests, and getting the attention of the tenants. I don't think that's a bad thing.
We can kind of touch on this a little bit too, but I think Ellen and Kim and Mike would all agree with me too. We tell you we are here to communicate. Your housing coordinator here at the authority is here to communicate with you. Mike and I and Kim and Ellen, of course, are also here to communicate with the landlord. That's why we're here. So we can't do anything unless you let us know. So, you're late, the tenant's late, they're late a second month, we can't, we're going to do our best to help you, but it's much easier to let us know. It's easier for us whenever you let us know as soon as possible so we can hopefully remediate the situation. So in addition to Michelle's response there. Okay, so what kind of assistance or concession, if any, do you generally look for a landlord to make before filing for eviction? You kind of touched on this a little bit, but maybe if you could just elaborate a little.
Yeah, I don't require or expect them really to do anything. Now, if they know for a fact someone is really able to pay right away, okay. But I don't expect them to make any kind of concessions, because like I said, the bank, if you have a mortgage on the unit or the house, does not accept, well, no, I'm really sorry, but, or I have these extenuating circumstances, but, and I know that probably sounds cold, but it's the reality of life. Like, you all have obligations, and the tenant has to understand that, and sometimes it's, you don't have to accept their word that it's coming next month, because I've been here so many times where I've sat in this court and heard and seen text messages, no, 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 it's coming, it's really coming, it's really coming, and the landlord gets strung along, and then it never comes, and your burden gets bigger and bigger. So I think it's a very personal choice for the landlord. And again, depends on the relationship. Maybe you've had this tenant, it's been a tenant of yours for years, and this is the first problem, and you trust, you know, that's totally up to you. But if you don't want to wait that long, I get that too.
Sure, sure. Okay, next one. Is it best to have a lawyer or represent yourself in an eviction? And then maybe just sort of a part A to this question, when is it a good idea to hire a lawyer in a certain situation? I guess it would be situational, but maybe you can answer that.
Well, one thing, if you are, I know a lot of landlords, even if it's just like a smaller operation, will incorporate. If you're incorporated, it either has to be a corporate officer or an attorney representing you. So, in Magisterial District Court, a lot of people don't know that, and a lot of MDJs don't necessarily abide by that, but it's something that you may get caught up in that you need to know. Okay, do not tell the Bar Association I'm giving this advice, but if you are a landlord who has been around the block and it's a garden variety, like you have your lease in front of you, bring your lease to court. That's something I did mention earlier. It's surprising to me how many times a landlord will come in and I'll say, okay, where's the copy of the lease? Oh, I don't have it. Okay, not a great idea. If you have a written lease, bring it with you. I'm sure you have a file on each tenant. Here's the lease they signed. Here's the renewal of the lease they signed. Here are the ledger we have. Bring all that to court. If you have all of that and it increases your costs. And if it's a tenant who's not gonna be able to pay, like I know a lot of times people that ask for attorney's fees, and if they're reasonable attorney's fees and necessary, I definitely order those. Not all judges will. So you're gonna end up paying an attorney when it's something that's, okay, pretty easy. Michele Santicola, I rented this property at 100 Main Street to Hannah LaPisca. She did not pay her rent. Here's the ledger. Here's the blah, blah, blah. Do you really need an attorney to be there with you? No. Now, if it's a contentious situation, if it's something that it's never a bad idea, but I'm just talking about cost effectiveness. If this is someone who's not paying their rent anyway, you may be out of luck, and then you're going to be doubly out of luck because now you're increasing your costs. It's never a bad idea, we'll say that, but is it necessary? I very rarely see landlords with attorneys.
Okay. I should have actually asked this earlier. In addition to another question, do landlords have to check a tenant's immigration status?
Yeah. Yeah.
Okay. Simple answer. Is there anything a landlord can do to evict since the terms of the lease have been broken? That's pretty general. Maybe you can give, maybe some specifics. Let's make this a situation. So, actually, I think someone had even given one here. So, refusing, let's say, early on in the process, can you refuse an applicant if they have multiple drug convictions? If they show up on, the portal or whatnot. I guess we'll start there.
Yeah, if an applicant is, I guess it would all depend where they are in the process, and then it's also different for Section 8 housing. I know there are different rules, and that's why I said to put in there about the, state, federal, and local law, complying with state, federal, and local law, and keeping everyone safe. And if somebody is a danger, if I would look and see, were they convicted of, everyone has a right to housing. Were they selling drugs out of their home, or so that's a Fair Housing Act and Section 8, both federal questions that are, I in the fear of giving legal advice, I would defer that question to, I would check with the housing attorney on that one. Because that's more of a, can we rent to this person versus can you evict them?
Mm-hmm. Okay. And you actually touched on that a little bit, finding out later if something, if they didn't tell the truth on something, you could, filing that way. So that makes sense. Okay, so the notice to quit proceeding, you touched on that a little bit, but can you explain, before filing a complaint with the magistrate, the, kind of the process there?
Right, so, the notice to quit, you have, so if it's the termination of the term of the lease, so your lease expired May 30th, you have to give notice to quit, within, if the lease term was a year or less, 15 days, more than a year, within 30 days. That's for either if it's a termination or a breach of lease other than failure to pay rent. If it's failure to pay rent, the notice to quit is a 10-day notice. So you just have to give, the different time periods, so you just have to be careful. If they're not paying their rent, you give the notice to quit a 10-day notice. If it's breach or termination of the term, and then also on the termination of a term, and then it's the same. You have to do it the same way as the posting service and but on the sorry, I'm losing my train of thought. On the termination of a term of the lease. So if somebody has a year-to-year lease and the lease term expires and they haven't renewed their lease, you haven't had that conversation, there's a question about what happens. And there's two schools of thought, and does it become month to month, or does it renew for another year? Number one, I would strongly suggest you put in the lease what you want to happen. So upon, expiration of this lease, failure by either party, something within 30 days of the end of this lease, we should come to terms for a new failure of either party to give notice of termination of the lease. The lease will automatically renew for whatever you want, a period of 1 year, or become a month-to-month lease. A lot of times this becomes an issue. People come in and, well, there's no clear understanding in the lease. Now, whoever drafts the lease, it's read against you. So typically that would be the landlord. The tenant's not going to come in and say, here's this lease. You wrote the lease, so you're stuck with the terms of it. And if there's any ambiguity, it's going to go against you. So if you want the lease to become month to month after, if there's a end of the lease term, if you want it to renew for another year, but then I would also put in the terms there, like at the end of this lease, failure of either party, will renew for another year with a rate increase of. Otherwise, it's going to be another year at the same rent. So just be careful in drafting. That's another drafting issue. And then if it becomes month to month, on the flip side, it's easier to evict them because like if somebody comes in and they say, you know, they haven't paid their rent, then okay, or breach the lease. If it's not within a year term, if they're just in a month to month, then just failure to pay rent, not just, I mean, that's pretty serious, but failing to pay rent, I'll grant possession. I won't even do the 10-day order because by the time, if it's a month to month, okay, so they cured it within 10 days. Well, it's, not gonna, so, that's sometimes if there's somebody who's notoriously difficult to deal with, or, you might want to keep it at switching to month to month.
Okay. Okay, I actually am going to take one question here because I think it's a good one.
Okay.
So say that a landlord has they have, let's just say it's a duplex and they own side A, side B, they do not own. They're the neighbor, but they don't own that. Side B is creating a ton of issues. And the landlord who owns the owner of side A has been reporting them to the city, with no luck. Any tip? I feel like I actually get some phone calls and emails about this, about other, tenant complaints and things like that from neighboring, buildings. Any advice there?
That's a tough one because really in that case, it's almost, it's risky for the landlord because the tenant could claim that they don't have, quiet use and enjoyment. And if the landlord has no ownership in that other, I mean, I guess the only thing, the landlord could file a civil action against the landlord of the other building. And or make police reports, or that's really a tough issue because you don't have control over that side. And yeah, I guess it'd be expensive to go down that path, but the only thing I can think of to do would be to sue the owner and or tenants of the other side of that duplex.
That makes sense. I feel like a lot of people complain about neighboring properties or, not taking care of the property next door, things along those lines, right? We all have, some of
Yeah,
us
and
have tough neighbors.
they can also file complaints with it depends on if they're code violations or whatever, to try to get that taken care of. If it's not up to code, if they're not taking care of the like the trash, the outdoor, they're letting it become overgrown. And one other quick thing that I forgot to mention, a lot of times tenants will come in and they'll say, I haven't been paying my rent because there's there's all these issues with the residents and or the apartment, and here that's why I'm not paying. Well, yeah, I say no, because the law says it has to be, if you're withholding rent, it has to be for the place has to be uninhabitable and it has to have been deemed so. You can't just decide it's uninhabitable. It has to have been deemed so by an authority, whether it's the housing authority or something. And then they have to pay rent into an escrow account. So people come in and they just want to say, well, I'm not paying my rent because of X, Y, or Z, and they want to show me pictures and they want to whatever. Well, there are actual rules that govern that. And so you can't just, it has to be a breach of the implied warranty of habitability. It has to be, the water wasn't working, half the electricity wasn't working. There was a danger. There was something that was, they're withholding the rent because of a true issue. If that's the truth, they have to give notice to the landlord. Can't just say, oh, well, it was like that. Okay, notice to the landlord, opportunity to cure. They have to allow, I've also had people, well, I'm not gonna allow them in here to fix this. I don't want, no. You have to allow them to they have to allow you to come in. And it has to have been deemed unfit by an applicable agency. And then they have to put their rent in escrow for the time it takes. And then the landlord has to fix whatever is wrong within a reasonable amount of time. So, is 6 months reasonable? No. It depends, if it's a broken furnace and it's July, well, maybe 3 months is perfectly reasonable. If it's a broken furnace in January, 3 months is not reasonable. So it's kind of one of those, when you see it kind of things.
Sure, sure.
It's not just a get out of jail free card that a lot of tenants think it is.
Um, okay, so it is 1:59 and we are not going to abuse you by any means, but I feel like I'm already getting so many thank you emails. So we just want to, spend the last minute thanking you very much for your time. Hopefully this was useful to everyone. I know it was for even us, and for our staff. I'm sure I can speak for them too. So Michelle, thank you so very much.
You're so
And yeah, for sure. Thank you, thank you, thank you. And I know Kim and Ellen, my directors, and then my colleague Mike Falls say the same thing. So thank you again. And this will be sent out to our landlords, and then I might be sending some extra questions that popped up to Michelle if she has time to answer them. So hopefully we can get to that. No promises. But this will be sent out to everybody just as you receive this email and in our Facebook group as well. Okay. Again, thank you
all
so
right.
much,
Thank
Michelle.
you. Bye, everyone.
Thank you. Thank you. Bye. Bye. Bye.
Thank you.